Welcome back, everyone, to another Canadian immigration podcast. This is another episode within our Express Entry Getting It Right series. I'm here, as always, with my faithful co-host, Alicia. How you doing, Alicia?
I'm doing all right, Mark, and we thought we would try to head off disaster for people because, when you've been working on your Express Entry application, you've got your profile in, you finally get that ITA, you're working hard on getting the eAPR finalized, and then you run into these statutory questions. And I think some people rush through them and don't read them carefully, and it can definitely tank your entire application. And worse yet, it can lead to a finding of misrepresentation and a bar for 5 years. So literally cannot apply for PR for 5 years.
Absolutely. So, where you're going to see these statutory information questions is after you get your invitation to apply and you're completing your eAPR. So, if we slide over here, I've got this as part of our course because you can't just go to it within your profile unless you have received an ITA. So, in the course, I'll just go down to the section, all these lessons. We're going to go to the completing your eAPR, and then it's found within the personal history section right in here. And so when you're completing your, what you've been doing over the last 10 years, it asks what your travel history is. And then the last component is actually the statutory information questions. And so what I've got here, I'm just going to flip over to this page, is the actual questions that you will see. Now, obviously, I've got them redacted because this is a real person's statutory information questions. And Alicia and I, we're going to focus today on some of the ones that are the most important. Obviously, if you are a international terrorist, it's pretty abundantly clear, what the question is asking. But it's the more nuanced questions that cause the most problems for people when they're applying. So right off the bat, Alicia, why don't we just hit with the very easy ones, which is this first one has, and we'll say, Mark Holthe been convicted of a crime or offense in Canada for which a pardon has not been granted under the Criminal Records Act of Canada.
Yeah, so that one's fairly straightforward. Most people will know if they've been convicted of a crime or offense in Canada and they have not been pardoned for that crime or offense in Canada. And that one's, pretty self-evident, and people ought to know if they have been convicted of a crime in Canada. So that one's not, I've never seen that one become an issue for people. It's pretty clear. The next one, though, does have a little bit more nuance, and it is a question that comes up also when people are looking at their temporary residence applications. So when they're doing a work permit, for example, when you look at the back of either the 5710 form or the 1295, if you're applying from outside Canada, there is a section on the statutory questions, and it asks a very similar question. So has the applicant ever committed, been arrested for, been charged with, or convicted of any criminal offense in any country? And
Mhm.
so this is not just a conviction, right? Keep in mind that they say committed. And so there's a whole section under the Immigration and Refugee Protection Act in terms of criminal inadmissibility on what constitutes the commission of an offense, even if there was not a charge or a conviction. And then there's also been arrested for or charged with. So even if you were arrested and not charged, you would still need to say yes and provide information on these questions. And I guess one thing that I will bring up as well is that sometimes applicants say, well, do I really need to disclose all this information? And the answer is yes. Yes, you do really need to disclose all this information. And the reason is Section 16, Sub 1 of the Immigration and Refugee Protection Act, which says that you have a duty of candor. You have a duty to fully and accurately answer questions in your application and also to provide documents that are complete and accurate. And this has been found time and time again. It's been confirmed by the federal court that no, people can't just hide. They have a positive duty of candor here. So yes, they've got to answer these questions.
Alicia, when I worked on the border, this is one of the questions that came up more than any others. We would ask, have you ever been convicted of a felony or misdemeanor? I was working on the land border crossing, so usually it was Americans coming up. A felony or misdemeanor, and people often, who had maybe more colored or checkered pasts would have been instructed by their immigration attorney in the U.S. That they didn't need to disclose anything when there had been an expungement or some other measure taken to wipe the slate clean for that person on the criminal records in the US, at least for the purposes of employment and things like that. So the equivalent of a pardon would be granted, and then the person would feel, well, I don't have to say anything about this anymore. But when we were on the border, we had full access to the NCIC database, the state records, and we could do a search. And if someone answered no to have you ever been convicted of a crime, well, that was a no-brainer. That was pretty easy. But sometimes they'd say, well, I didn't know that that was a conviction. So then I was instructed by my supervisors at the border to ask, have you ever been charged? Have you ever been detained? Have you ever been handcuffed? Have you ever been fingerprinted?
Yeah.
To close off every avenue. So then, if they truly did say no, then as I was listening to the other officer in another room, this is back in the early 2000s, when they were running a search on the person, I could hear this dot matrix printer going, zzz, 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 and these accordion pages that were all attached. And then they'd come and they'd bring this stack of pages where I'd open it up like this, and it'd be like this accordion full of records. And and I was like, maybe I'll ask you that question again. Have you ever been, convicted? They're like, well, oh, my immigration attorney, sorry, my criminal attorney in the States told me I didn't have to say that. Well, you are crossing an international border, and we see everything, and it may be, it may be suppressed, but it's always there. And so those are real issues, and people are always getting tripped up with this.
And maybe Mark, well, because now actually on the express entry statutory questions, they've divided this question in two. So if you look at the
Mm,
work permit or the study permits, they have a slightly different way of asking this question. But maybe if you scroll all the way down, just because we're talking about criminality and
mhm.
inadmissibility, there's another question that very clearly also says, have you ever been detained, incarcerated, or put
Right
in
there.
jail? So they've broken this question up into two sections, I think, to try to highlight for people that these are two separate matters, right? Even if you weren't convicted, were you ever detained, handcuffed, incarcerated, put in a jail cell? If yes, then you must provide the details of that.
Yeah.
And so you're absolutely right, Mark. I've also had clients from the UK who have had these
Uh,
UK rehabilitation of offenders
mhm.
provisions where after a certain period of time, the slate gets wiped clean, and this doesn't actually appear in their criminal record search, their ACRO search anymore. But they were charged or they were arrested for that crime, even if it was subsequently pardoned or rehabilitated. And they still have to say yes to this question because you're absolutely right. The way that domestic law, and if you look into all the UK provisions as well, it clearly says, this rehabilitation only applies within our jurisdiction. If you are crossing international boundaries and making an immigration application, well, then all bets are off. You've got to disclose.
Yes. And one of the things that we would always key on with UK criminal record reports was the distinction between no trace and no live trace. And in the past, that live indicated that there was something there in the past that had then been pardoned through the UK Rehabilitation of Offenders Act. So watch for those things for yourself. And if you are, a representative, those are things that you want to watch out for and ask these questions. All right, let's continue, Alicia.
All right, so the next one, has the applicant ever made previous claims for refugee protection in Canada or at a Canadian visa office abroad or in any other country or countries or with the United Nations High Commission for Refugees, the UNHCR? So it's not just a Canadian refugee claim, it is any type of refugee claim anywhere.
Yeah. And yeah, people, that's another thing. People, they just assume, oh, it's in Canada. And nope, never made a claim. And sometimes when you're young, Alicia, this also becomes an issue because if you were a minor, you were accompanying your parents, all of these questions you have to be very careful for because they don't say anywhere here, Alicia, that these questions are to be answered based on from the age of 18 or more, like when you're an adult. They just ask, has this ever happened? And when it comes to these applications for refugee status, or as we get down a little bit further, applying for a visa and have you ever had one refused, you may not even know.
hmm Yeah, and so this next one is the one that tends to trip people up because they stop reading. And so this one's fairly long, and it says, has the applicant been refused refugee status? And then they're like, well, I just answered that question. No, I haven't been refused refugee status. I didn't even apply for it. But you need to keep reading because it says, or an immigrant or permanent resident visa. So it's not just refused refugee status. Were you ever refused an immigrant or permanent resident visa, including CSQ, so Certificat de Sélection du Québec, or an application to the Provincial Nominee Program, so a PNP, or, and not just permanent residents, now it turns to temporary residents, or a visitor or temporary resident visa to Canada, and here's the kicker, or any other country,
Yeah.
ever.
Yeah. Yeah. And, these questions, Alicia, are just so poorly worded. In my mind, they should all be broken up into individual parts so that people can address them individually. Because, like you said, even a refusal of a PNP application, you're to disclose that. And people often get very, very confused and they're uncertain as to whether or not something is an actual refusal, which really we should probably read both of these questions together because this one is all about technically, I know where they're going. They're saying, okay, have you ever applied, like made an application for any kind of a visa and it was rejected? That's kind of what they're getting at with this question. But when you look down here, it says, have you ever been refused a visa or permit, denied entry or ordered to leave Canada or any other country? This is more, have you been prevented physically from entering or have you been asked to physically leave? But it's not really worded that way. So
Mhm.
it still says, have you been refused a visa or permit? Well, technically that right here could encompass everything up here to some
Right.
extent. And
Yeah.
so whenever we're doing this, answering these questions, something that comes up frequently is, oh, I flagpoled to the US. So how do I treat that flagpole? I don't think it was a refusal, or was it refusal? How do you address things where it's just gray?
hmm If there is any doubt, you disclose it ad nauseum. And so you say yes. And then if you do not have space, and this is something that I've heard over and over again as well for people who are unrepresented or doing their own application, oh, there wasn't enough space in the little box. So I just said yes, and I only gave 2 lines, but it actually was 3 lines worth of refusals, and I didn't mention the older refusals because I didn't have space. IRCC does not buy that. The federal court does not buy that. That will not stand up, and you will be found to have misrepresented if you did not attach another letter of explanation and fully declare and disclose everything, even if it doesn't fit in the boxes.
Yeah. And with this in express entry, there's a lot of room in the box to explain. So you aren't faced with the same character limitations that you often are with the PDF forms. So don't don't hold back. You don't need to write a whole bunch of paragraphs or an essay explaining what happened. But Alicia, when the answer is yes, what are the specific information? Well, like what's the essential components that you always include when you are, providing an explanation of why you've answered yes?
hmm So if it's yes, then most of the time it's going to be yes to both of these questions, right? If they were refused a permit or a visa, you're going to say yes to the first question, yes to the second question, and then you're going to expand. So how many permits? When was that it was refused? What were the circumstances around it? Why was it refused? Was there a subsequent approval or what happened with that refusal? You're going to put all those details as part of your explanation for what happened.
Yeah. And when you do that, you are insulating yourself from misrepresentation, a finding of misrepresentation, right? It's the failure to disclose something that you should have, or of course, by commission, saying something that was just not true. And technically, if you said no and the answer was yes, that would be misrepresentation by commission. You're actively responding incorrectly and in a way that would be considered potentially to be misrepresentation. So when we're filling the details in, like I said, you don't have to provide an explanation. And sometimes, you guys, you don't know exactly why it was refused. The reasons are not super detailed. So I've never found a situation where someone has got into trouble when they've disclosed it and haven't provided an essay in terms of an answer. It's only been situations where an individual has just said no when the answer should be yes. but you still want to be careful. You want to identify exactly what you applied for, because Alicia, if my memory serves me correctly, I think there was a federal court case at one point where they upheld a misrepresentation finding when a person failed to disclose the third of three US visitor visa refusals. They disclosed 1 and 2, but forgot number 3. And there was a finding of misrepresentation because they had not disclosed the third one.
Yeah.
Ultimately, whether that's going to have an impact, a material impact on the processing of the application, I guess is another question, but that's how serious they take this.
Yeah, and Mark, circling back to what you said about those flagpoles, and when we did a podcast on flagpoling and the risks of flagpoling, sometimes people don't actually realize that the document that they were given by US authorities was technically a refusal to enter the US,
Mhm.
even if their Canadian work permit was issued or their study permit was issued. And so, just like Mark said, be super careful. Or I always tell people to go and ask their parents, did you ever apply for a visa for me, even while I was a kid, right? If, let's say, you were living um, in China and your school group wanted to come to the US and you applied for a visa and it was refused, you've got to disclose that. So, those are things where you've got to be super, super careful, go through and carefully examine all of your past because there's no time deadline on this. It doesn't say age 18, it doesn't say the last 5 years, it doesn't say the last 10 years.
No, it doesn't. On the topic of misrepresentation, which is not the topic of this podcast episode, I do want to direct you back to our YouTube channel, because if you go here, and you should be able to search here, and if you just type in misrep or whatever you want, this little juicy little video here that Alicia and I did a couple years ago, wow, 3 years ago now, on misrepresentation, it was a Halloween special. You definitely want to go check that out, because we discuss this in a lot more detail, and we don't mean to scare you. What we mean to do is to terrify you guys into not failing to disclose what you should be disclosing, because the consequences often are far greater for saying no than they are saying yes and disclosing what actually happened. And in many cases, especially when it comes to prior visa refusals, those do not have a significant impact on your permanent resident application in most cases. They just want you to tell the truth. And so just watch for that.
Mhm.
All
So the
right.
The
Mhm.
yeah, the next few we kind of touched on refused a visa or permit, denied entry or order to leave. So be careful, even if it wasn't a refusal of a permit, if you were turned around at the border and not allowed into a country, that you have to say yes and
Yeah.
explain.
And especially the Canada US border, because everything is tracked and they can see it. So
Mhm.
there's nothing that you're going to be able to hide if it happened in the US or Canada or one of our partner countries.
Yeah. The next one, this is pretty evident
Yeah,
if you've
these
been
are,
involved
yeah.
in an act of genocide, a war crime, commission of a crime against humanity. This is big bad stuff. Used, planned, advocated the use of armed struggle or violence to reach political, religious, or social objectives associated with a group that uses, advocated, or advocates the use of armed struggle or violence to reach political, religious, or social objectives, or been a member of an organization that is or was engaged in an activity that's part of a pattern of criminal activity. So all those are
Essentially gangs. Yeah.
pretty serious. Yeah. Um, so then the next one that we talked about already with
Mhm.
respect to criminal inadmissibility is detained, incarcerated, or put in jail. The reason, Mark, that they're asking all these things is because of equivalency, because a crime in a different country could be very different than a crime in Canada or what Canada considers to be a crime. So even if somebody was not charged or convicted of a crime in a foreign country, the fact that you were incarcerated or detained or put in jail for that could be relevant information for an analysis for an officer to say, well, wait a minute, that actually would have been a crime had it occurred in Canada. So that's what they're looking at. So you do have an obligation to be truthful. And this next one is one that is also serious because it's very broad. So there's a similar question that's asked in study permits and work permits and temporary resident applications. But in terms of the express entry application statutory question, it's has the applicant had any serious disease or physical or mental disorder? And there are all sorts of variations on this. And
Yeah.
I often have clients say, well, my child has ADHD. Does that count? My child has autism. I have a malignant tumor. Well, yes, that is a serious
Mhm.
disease. I have a benign tumor. Is that a serious disease? Maybe. So there are a lot of things. If you've been diagnosed with some sort of mental disorder, that's something that needs to be disclosed here as well.
Mhm.
Um, People are trying to figure out, well, what's serious?
Right.
Well,
Is depression serious?
yeah,
Is it,
yeah.
what's the distinction between, I've been seeing and seeking help for depression versus I am, clinically depressed versus I'm recovered and I'm fine now? And so whenever you're in these kinds of situations, people often, Alicia, I get these comments and I see them online. People are like, well, don't disclose it because then it opens up a can of worms and then it's going to delay the processing of your application. My goodness, you guys, you do not want to in any way, shape, or form speed up the processing of your application, which then results in a refusal because you chose not to disclose any of these things. It's better for you to disclose fully, let it run its course, let it take its time to be properly assessed, and avoid the likelihood of a misrep finding.
Yeah, and so what they're getting at here is medical inadmissibility. And we know that there's different types of medical inadmissibility. Most of them are dealing with excessive demand on health or social services. That's what they're looking at here. They're not usually worried about public health or public safety. That's more of like a tuberculosis or an active disease where they're screening as part of the immigration medical. But the thing that they're looking at largely here is excessive demand on health or social services. And this comes down to a costing analysis. And so there is a cost threshold. The cost threshold for 2025 is Canadian $27,162 per year, or, and this is important because they also look at the average over 5 years. So over 5 years, the cost threshold for 2025 is $135,810. And so they're going to look and see whether the cost of care for health and social services is going to exceed the Canadian cost threshold for what the government is expecting to pay for most Canadians over a 1 year, 5 year period. And if it is, then it's something where you could be potentially medically inadmissible, and you're going to want to come up with a mitigation plan. You're going to want to reach out to an immigration lawyer that deals with medical inadmissibility on a regular basis. You're going to want to try to find if there's some way that you can defray those costs with private insurance or come up with a solution, but you definitely can't hide it.
Yeah, you do not. So there you go, everyone. That is our breakdown of the various statutory information questions that you will find within the express entry process and permeating throughout a lot of the other immigration applications you'll submit to Canada. The one overriding piece of advice that we will reiterate over and over again is it is better to disclose when you're in any kind of a gray area or uncertain. It's better to disclose and then have the opportunity to let it kind of run its course, and you can provide more details. And in many cases, the areas that are gray, when you disclose, they're not an issue. It's the issue becomes when you choose not to disclose in an area that's gray, and then an officer says, well, you should have, and that's misrepresentation. So often we find the misrepresentation consequences are far greater almost in many cases. Obviously, it's subject to what you're actually disclosing, but then the actual failure to, that whatever you did, like the refusal to the US for a visa in and of itself. So any other final little pieces, Alicia?
One last thing, because I was looking through some case law
Hmm.
before we started talking about this podcast. Sometimes applicants say, well, I already disclosed that refusal on my last study permit or my last work permit, or immigration knows about it because I told them about it before. That should be fine. They can't say that I've misrepped if I told them about it before. Yes, they can. So you still have an obligation, especially on your express entry application when you're applying for permanent residency, to reiterate and disclose everything, even if you put it in prior applications. And the federal court has literally said that the applicant should not make assumptions about IRCC's knowledge of their own past history.
Yeah, absolutely. All right, everyone. Thanks for joining us in this episode of the Canadian Immigration Podcast, another within our Express Entry Getting It Right series. We will be back again in the next one covering more topics like this. Take care. Thanks, Alicia.